Hello, I'm Jill Marshall and I'm a law professor at the University of London and the convener and chief examiner of the jurisprudence module. I will be talking in this lecture about Part 1 guidance, what is expected. Moving on to the next slide, you will see the purpose of this recording. I hope you're enjoying the course and find this lecture useful in preparing for your assessment. I've been asked to focus on skills that will help with the seen element of the exam. For jurisprudence, this is part 1 of your assessment. You have been provided with a case, which is known as the set case in your part 1 guidance, as clearly explained on the VLE, the Virtual Learning Environment. I have been asked to provide you with this recording, which looks at a different case to the assessment or our set case, but demonstrates the skills required to answer the question well. So I will be focusing on a different case, so please be very clear that this is not the case you are to analyse for the purpose of the upcoming assessment, but it is used here as an example to help your skills. There are 5 discussion questions to go with the recording and the related discussion forum. So those discussion questions are set out here. 1. What should you be demonstrating in your answer to part 1? 2. What is natural law and how might natural lawyers interpret a case? 3. In terms of your jurisprudence module, what does liberalism and law concern? 4. What is Dworkin's theory of law? And 5. How do 2, 3 and 4 relate and apply to the example case? I will monitor the discussion forum and answer any relevant questions as appropriate. So what is the aim of part 1? This is to help you to prepare now for part 1 examination. And to do that, the set case has been released in advance. And you've been directed to study it in depth from the perspective of particular legal philosophical theories selected from the syllabus. Now, as pointed out already, the chosen example that I'm discussing in this recording is not this year's set case. This year's set case is our Ledger versus Secretary of State for Education from 2025 on the citation given. And it is this set case that you'll be examined on. The examination questions will be derived from the 3 jurisprudential theories related to the set case. To prepare for this part of the assessment, you will need to read the given case in depth and to focus on applying general theories of law to real contexts. You're advised to research academic writings on the case to help and aid your understanding and ability to critique and evaluate the judgments given in the case. The aim of this assessment exercise is to develop your skills in identifying the relevance, the significance and the applicability of general theories of law in real contexts of legal practice. You'll be able to identify possible clashes between competing theories of law within those contexts and to discuss critically how the theories in the question relate to or apply to the set case. This is to enable you to develop the ability to think about the decision and legal practice in general by questioning its foundational presuppositions with the help of general legal theories or jurisprudential reading. So let's move on and the example. So my example for the purpose of today is the case RTT versus the Registrar General for England and Wales from 2019. The starting point is to read the relevant case. Always note the exact citation and which level of court case you're being asked to examine. You should give yourself a good time to read and immerse yourself in the court judgment, to consider what the case is about, what are the facts, what is the area of law, and what legal issues are being decided. So the facts, areas of law and legal issues at stake. Ask yourself what the case is about in one phrase or sentence. For example, this case of RTT concerns the question, what is a mother-in-law? In this case, new issues in equality law are at stake. The President of the Family Division ruled, in this level of the court case, that a person who undergoes the physical and biological process of carrying a pregnancy and giving birth must be registered as the baby's mother, even if they, the person giving birth, are legally recognised to be of the male gender. In this case, the claimant's registered gender at birth was female, but he lived for many years as a transgender male and had been granted a gender recognition certificate under the relevant UK law to this effect. In 2016, following IVF, he gave birth to a baby. It is a legal requirement to register the birth of a child in the UK. After the Registrar General held that the claimant had to be registered as the mother of the baby on the birth certificate, the claimant sought a declaration that as a matter of law, he is to be regarded as the father on the basis of Article 8 of the European Convention on Human Rights 1950, as set out in the Human Rights Act 1998. This provision provides a right to respect for one's private life, home, family and correspondence. This is one of the first domestic cases to deal with the impact of gender reassignment with respect to parenthood, and the High Court held that the claimant had to be registered as the mother, following law in the past that the one who gives birth is mother. This case is discussed in many blogs, many posts on the internet and other internet sites. For your own assessment, you can read up for such materials, but remember that the most important thing to do is to read the case for yourself and to consider it in the light of the 3 areas of theory specified in Part 1 guidance document. For the purposes of your preparation for the assessment, therefore, know the set case clearly, having read and studied it. And know the 3 theories you have been told will be examined this year. The 3 theories this year are natural law, then liberalism, and then Dworkin. So you're asked to see more detail in Part 1 guidance, which is on the VLE. In relation to the example set out in my lecture today, I have some links to a blog and a podcast should you be interested. For the purposes of the assessment, we are not interested in the substantive questions of law raised in the case, but rather in the legal philosophical relevance of the case. For example, the way that the judge analysed existing law on defining mother. How might this work in our current society today, where people's birth gender can be legally changed, and where medical developments enable the birth of a baby from a legally defined man? There are many ways in which you might analyse any given case, hence the examiner provides you with direction to your studies by asking you to consider the case in the context of particular jurisprudential theories. For the purposes of this lecture, this example case is now related to natural law theories, liberalism and law theories, and Dworkin's theory of the law. So accordingly, questions in the examination might be as follows, and these are just some examples of what the question might be. These will of course vary, and these are not going to be the questions that you will be given in the exam because the questions aren't given in advance, only the topics. So firstly, in what ways would natural lawyers agree or disagree with the judgment and analysis used by the judge in this case? You need to set out what the facts of the case are, what the area of law is, what the legal issues are. Then you need to explain what are natural law theorists' views of law. Your answer to the question will interconnect this with different theorists of natural law and underlying views of aiming for or emphasising human flourishing in some way, and of law relating to the common good, and of following or reinforcing what is natural or occurs naturally, or is deemed as doing so. It is for you to explain what overarching natural law theory, and to explain why you may focus in on a particular theorist, such as, for example, Aquinas. You will demonstrate whether the theorists may agree or disagree with the judgment and the analysis used by the judge in this case. So this is for you to show or demonstrate. You could set out a different perspective. Clearly set out your perspective in your introduction and see the relevant chapter and topics on the VLE for more theoretical details and content. Question 2. Again, this is an example question. Critically evaluate how this case relates to what is important to liberals in a democratic society. You should consider different theories of equality, of rights and justice, notions of paramount concern to liberals. For example, the relevant chapter topic of liberalism and the law on the VLE sets out theories by theorists such as Bernard Williams on equality. He argues that equality has a special meaning in morality to strike at unjustified statuses and hierarchies. One of the reasons we approve of equality of opportunity is that we think that everyone, because of their common humanity, should have some sorts of chances in life, even though some do not, perhaps cannot, take them up. But there are problems with the idea. Some people are for more freedom and less equality. They say they oppose equality because it is uneconomic and stifles human endeavour, enterprise and creativity. And having in mind equality as it was interpreted in the former Soviet bloc countries, for example. Some say we should have more equality and less freedom, and these people are usually for more state support and intervention, particularly in the real marketplace. Not everyone can exercise freedom to the same extent, but healthy and intelligent people who have a certain type of attitude may take freedom away from others by manipulation and exploitation. You should consider where you stand in all of this, but it's useful to have some tools at your disposal. One is that you should note a famous difficulty with the idea of equality, which is that it is claimed to be an empty ideal. Note first the comparative nature of equality. Someone is equal to someone else. Someone is unequal to someone else. It requires a judgment about the extent to which one state of affairs matches up to or compares with another. The equality ideas and other relevant concepts, depending on the question you're asked, could then be applied to the example. Is the claimant being treated as an equal if he is registered on the birth register as a matter of public record and his child's birth certificate as the child's mother? You might also want to consider the Hart-Devlin debate in the context of differing views on how to describe a birth giver. Can it be used and made up to date in the context of this issue? Have a look at the VLE and all the readings around that and decide for yourselves. And question 3, again, this is a fictitious example question. How would someone applying Dworkin's theory decide this case differently, if at all? You should consider clear pointers of Dworkin's theory. He showed dissatisfaction with the rigidity of the distinction between descriptive and normative accounts of law, and Dworkin introduced into his theory the methodology of the interpretive concept. So note that Dworkin opts for the spelling interpretive rather than the more classically correct interpretative. Dworkin says that the essential idea in interpretation is making the best of something that it can be. And this very abstract idea is to be applied to the idea of law. The idea of making the best of something can be described in several ways. The quickest way to the idea is through the notion of a thing having a point. For example, ask yourself, what is the point of the thing you're interpreting? The way you might ask yourself, what is the point of the prohibition of vehicles in the park in the course of producing a legal argument about roller skates? Or, in our example here, what is the point of defining mother in this context? But another metaphor is that of placing a thing in its best light. We assume that the thing has some point, and we examine it as thoroughly as we can to see what is the most sensible way of viewing it. Is it sensible to view a man as a mother? Further, Dworkin creates an imaginary, perfect judge, Hercules. The key to what Hercules does is in the following idea, and this is a quotation. If a judge accepts the settled practice of his legal system, if he accepts, that is, the autonomy provided by its distinctive, constitutive and regulative rules, then he must accept some general political theory that justifies these practices. And I've used the word he because that is what Dworkin uses, but of course it means he or she, or they. And what does Hercules do when constructing the arguments in all the hard cases put before the judge, Hercules? We can assume, says Dworkin, that Hercules accepts most of the settled rules of their jurisdiction. Rules which lay out for us what are the familiar characteristics of the law. For example, the constitutive and regulative rules that grant the legislator the power of legislation. These give judges the power of adjudication and the duty to follow previous cases, as well as all the settled rules of the various areas of law, such as tort, contract, and so on. So according to Dworkin, Hercules can produce theories underlying all these rules. Democracy, in some form, clearly underlies the legal jurisdictions, for example, of the USA and the United Kingdom. So we have there a basic justification for judicial coercion in accordance with what the legislator has required. But this is only the beginning. The justification for the common law doctrine of precedent lies in the idea of fairness, the idea of treating people in a consistent way. The justification for particular applications of statutes and the common law lies within more elaborately worked out theories or reasons. And Dworkin explores distinctions also in his theory between principles and policies. So you need to know all of this detail and see more detail in the relevant sections on the VLE. So in general, you need to write clearly written, coherent and well-structured answers to all of your questions. And as I said, that applies to part 1 just as much as it does to part 2. Have a clear introduction showing how and why you've interpreted the question the way you have. Explain in your introduction how you're going to answer the question, setting out the structure you will follow. So, for example, you're going to say in your introduction that your essay will be in 3 parts, ending with a conclusion. And you set out in themes or by reference to firstly the case, then the theory, then applying the latter to the former. You will take a position. By this I mean you have a view for the purposes of the essay that you will agree or disagree with the statement in the question, for example. You might want to start with a quotation or something interesting to obtain the examiner's immediate attention. Remember, this is your essay, so do not plagiarise, do not cut and paste and make it seem like it is your own original thought. Think about what and how you could write relating the content of the course to the question asked, and own it. You are the author. There is no model answer. You write it in your own style. So show knowledge of the information Show evidence for your position supported by primary and secondary sources. Convey your reflection and thought on the issues raised to analyse the materials and criticise them constructively in appropriate professional language and style. In terms of writing the main body of the answer, this will be the longest part of your answer, about 2/3 of your essay. So in this main body of your answer, you will present the reasons supporting your view of the topic set out in the essay title. You'll be drawing extensively from the existing literature, as well as put forward original remarks. You'll use headings that relate to your arguments if you consider this relevant, and do not detract from the flow of your writing, all as you will have highlighted in your introduction. Have a clear conclusion. Don't put any new points in or any further support or expansion of your views. Just sum up what you've said. It needs to draw together the threads of the argument developed in the main body of the essay, summarising your position. So think when you're rereading it, try and give yourself enough time to do that. Does your essay clearly set out your ideas and explain their significance? Does your writing flow from section to section? Is each of your major points supported by the appropriate amount of evidence and analysis? Is anything confusing or inconsistent? And if so, edit or rewrite it. Don't have anything plagiarised or cut and paste without crediting the source. Your own words or short direct quotations with quotation marks with the source clearly stated are required. Try to make a good first impression on the examiner. So try not to have spelling errors and also avoid abbreviations such as don't, haven't, etc. And then think, have you conveyed your knowledge on this topic to the reader or to the examiner? So do think about all of those points as you're rereading and finishing your papers. As you can see, this is the end of this lecture. I look forward to any related points on the discussion forum, and thank you for your attention. Many thanks.